I'm Cornell Clayton, Director of the Foley Institute. On behalf of the Institute, I want to welcome you out to our event. This is one of our ongoing in the series on the 2024 election, which, remember, is next Tuesday. So if you haven't voted, get out and vote. Next Tuesday, same time, we'll have in here an election prediction panel starring the greatest minds in political science at WSU, Travis Ridout being one of them. But that's always fun. We'll have a good time. There'll be Travis Ridout, Todd Donner from Western Washington University, and Carolyn Long, who's from WSU Vancouver. Will be on that panel, so that should be a lot of fun. Today, however, we're fortunate to have with us Scott Lemieux, who is an associate professor of political science at the University of Washington. And in his work, he specializes in judicial politics in American political institutions. He is the co-author of Judicial Review in Contemporary Democratic Theory, Power, Domination, and the Courts, published by Routledge. And he has contributed to a variety of scholarly journals and more popular media outlets such as the New Republic, the American Prospect, the Guardian, and the Los Angeles Times. He's going to be talking about the role of the court in the election. So join me in welcoming Scott Lemieux to the Foley Institute.
Well, thank you very much for attending, anybody, and I'm extremely grateful not to be on the election predictions panel. So thank you for that. Thanks for coming out. So today I'm going to try to try to describe what's at stake, for the Supreme Court and the upcoming election, and kind of sketch out some scenarios, both kind of for the shorter term and for the longer term. And to do so, I kind of want to provide a little bit of historical perspective and detail, with which to sort of, think about how, the judicial confirmation process is changing, and how, the stakes surrounding the Supreme Court are changing. And again, I don't think that's a very hard sell to say that the impact of the Supreme Court is very high right now, but I'll kind of try to go through some of that history. So we can start here, and these are ranking the justices by the Martin Quinn score. So this is the most commonly used method by political scientists to sort justices ideologically. Now, this is, like all models, this is far from a perfect measure, and I would particularly say that using Martin Quinn scores to compare justices from different eras doesn't work. It's really a relativistic measure. It measures kind of ideological factions within a current court, and I think, a really good qualitative analysis can always quibble, and these scores can also be affected by the case flow of a particular term. So my guess is that in future years, you're not going to see Justice Jackson to the right of Justice Kagan. That was just sort of a couple of cases that came down this year. But it's useful, I think, at least in broad terms, in terms of identifying roughly where we expect justices to vote. As you can see here, we have 3 justices on the left in blue, and we have 6 justices in red. And this is sort of at the heart of what has changed about the court. And to be clear, what has changed about the court is not that there are ideological patterns in voting. There have always been ideological patterns and ideological factions in voting. Never perfect. And one thing is that in some cases, the 2 votes that the political science models don't predict are the 2 interesting votes. If you think of the case in which the Supreme Court said that the Civil Rights Act protects sexual orientation, sexual identity, this model would get 7 of the 9 votes right, but the 2 it gets wrong, Gorsuch and Roberts, flip the case. So there's limited, but I think there are general sort of recognized ideological patterns. That's not new. What's new is that they map precisely onto partisan lines. And you might think that that isn't a new phenomenon, but I'm going to show you a counterexample to show that that actually is. And the key is that the fact that ideological and partisan divisions on the court now map pretty much perfectly is precisely what is sort of driving the changes to the confirmation process, and which makes each judicial confirmation such a high-stakes endeavor. So the key thing here is that in the mid-20th century, there was much less polarization among political elites than among ordinary voters. So that the difference between the Justice Department under Truman and the Justice Department under Eisenhower was not all that big. There was sort of less, differences between, a Republican-appointed judge and a Democratic-appointed judge, because, sort of educated legal elites kind of had predictably different views than the public, and so they just kind of, and there were exceptions, but they tend to come from a fairly broad consensus. In 2024, of course, is the precise opposite. There's much more polarization among political elites than there is among ordinary voters, and there's a particularly high level of polarization among legal elites. And this isn't something that just happened. My friend Sam Rosenfeld has a great book called The Polarizers about how party polarization was driven by choices made, going back to political scientists in the 50s and then movement conservatives in the 60s. So it's come from both ideological directions, and that's definitely happened in the legal world. Obviously, you have the rise of the Federalist Society on the right, and then some attempts for counter groups on the left. But there's been a very conscious effort to ensure that that judicial appointments are relatively ideologically reliable, which means that polarization among legal elites is much more. And so again, it's not new for there to be ideological coalitions and factions on the court, but it is new that the ideological and the partisan divisions are precisely the same. And the obvious upshot of this is that this greatly increases the stakes of Supreme Court confirmations. So you think of March 2016, when Justice Scalia unexpectedly passed away. The result of that was going to be either a median vote in the court of Merrick Garland or Elena Kagan, depending on who Obama nominated, or it was still going to be Anthony Kennedy. If a Republican was able to place that spot. And so I think in that context, it's not really surprising that Senate Leader McConnell would not have a vote, simply the stakes were too high. I do think what some people forget is that was a real gamble. A lot of people expected Hillary Clinton to win, and Merrick Garland is probably the sort of oldest and most moderate, viable Democratic nominee. So he absolutely could have lost that gamble to some degree, but I think the calculation here is that the difference between Garland and any other Democrat is going to be much smaller than the difference between Garland and any Republican nominee, and I think that calculation is correct, and that's exactly why McConnell and Senate Republicans did what they did. And it wasn't completely unprecedented. Obviously, LBJ's attempt to replace Earl Warren in 1968 was filibustered to death by a coalition of Southern Democrats and Republicans, but it's the first time in which Supreme Court nominee was not even able to get a hearing, and it does, I think, is a real harbinger of things to come. That I think that sort of shows us where we are now, but I don't think it's partly sort of McConnell's particular politics and vision, but I also think it's just an inevitable byproduct of the process that when you sort of know what the stakes of Supreme Court nominations are going to be, and it makes a huge difference on a huge range of issues, that's just not going to be you're just not going to be able to get nominations confirmed by opposition Senates. And again, if you look at the court in 1988, and this I just pulled this up. This was the vote in a case called Webster versus Reproductive Health Services. One of the first major attempts but unsuccessful attempts to overrule Roe versus Wade. You see the justices here lined up from left to right. So at the left of the court, you had Thurgood Marshall, who was nominated by LBJ. But you have William. Anybody know who nominated William Brennan? So, I know Cornell knows. Dwight Eisenhower. So the sort of the liberal heart of the Warren Court was actually an Eisenhower nominee. You have Harry Blackmun, who was nominated by Nixon after his first two attempts to fill that position were defeated by the Senate. The second, Roman Haruska was one of his, the second nominee, Harold Carswell, one of his defenders, the Nebraska Senator Roman Haruska, said, maybe he's mediocre, but aren't mediocre people entitled to a little representation too? His nomination failed. But ultimately, so Nixon relented, nominated Harry Blackmun. And Blackmun's a bit of an interesting case in that, in his first years, he actually had a pretty conservative voting record. He'd actually been the best man at the wedding of Chief Justice Warren Burger. Since they're from Minnesota, they were sometimes referred to as the Minnesota Twins. But in part because Burger made what turned out to be not a great strategic decision to assign Roe versus Wade to Blackmun, who had been the general counsel of the Mayo Clinic and kind of spent the summer researching it. Blackmun was also somebody who literally read all of his mail and was kind of sensitive and insecure. So not surprisingly, years of getting barrages of supportive letters from Democrats and angry letters from Republicans tended to move him to the left. So by the time he left the court, he was actually on the left part of the court. But again, another Republican nominee. And same thing, John Paul Stevens, who if anything would drift further to the left as he stayed on the court, the only Supreme Court nominee of Gerald Ford. So of the four dissenters in Webster, 3 of them were nominated by Republican presidents. On the other hand, we have at the center of the court Byron White, who's nominated by John F. Kennedy, and he was a little ideologically idiosyncratic. Whereas some justices kind of changed with their coalition, White just stayed what he was in 1960, which was kind of an old-fashioned law and order Kennedy liberal, which meant that he was still liberal on issues like civil rights and national power, but was very conservative on things like criminal procedures, civil liberties issues. And he was one of the 2 dissenters in Roe versus Wade and never backed off that. So, one of the justices who always believed that Roe was wrongly decided and should be overruled was actually a Democratic nominee. And then we have Anthony Kennedy, nominated by Reagan after Robert Bork's nomination was defeated, which you sometimes heard people argue that Roe versus Wade was never in danger because Republicans wanted to keep it around. We know that's not true because had Robert Bork been confirmed, Roe would have been overruled in 1992. So this was not a planned strategy on the part of Republicans. It was that their preferred nominee got defeated in 1987, and Kennedy ended up in 1992 keeping Roe alive for another couple decades. Senator O'Connor, the first nominee of Ronald Reagan, Anthony Scalia, another Reagan nominee, and then William Rehnquist, who had been nominated as an associate justice by Nixon, and was then nominated as Chief Justice to replace Berger by Ronald Reagan. So you can see on the right of the court, there's only 1 Democrat, but the left of the court has 3 Republicans. So this is still a remnant of the era in which we had relatively loose party coalitions, in which there were quite a few liberal Democrats or liberal Republicans, and quite a few moderate and conservative Democrats. And you can also see the center of the court for a long time tended to be either sort of old-fashioned country club Republicans like Kennedy or O'Connor, or kind of an old-fashioned law and order Democrat like White. And basically, one thing about the current court is that whole genre of people is now essentially extinct as political figures. I don't think a Republican president could nominate somebody like Kennedy even if they wanted to, because they don't really exist anymore. So that's what's changed. It's not as if it's a new thing for there to be ideological faction on the court. It's those ideological factions mapping perfectly on to partisan faction that's really made the difference. And you can see this, if you look at how voting has changed in confirmation votes as well. That there used to be a pretty strong norm of deferring to presidential choices unless somebody was viewed as radical or unqualified. But you can see that Anthony Scalia, one of the most conservative members of the court of the 20th century, was essentially confirmed unanimously. And indeed, one of the ironies is that had President Reagan nominated Robert Bork in 1986, and Republicans still controlled the Senate, and nominated Scalia in 1987, most likely he gets both nominees with a lot of historical impact. So that's kind of an interesting contingency there as well. Kennedy again, and that's a big difference, is that when Bork was defeated, it wasn't as if Ronald Reagan was denied any opportunity to make an appointment. He just nominated a more moderate conservative and was confirmed essentially unanimously. So again, it's not as if it's new for the Senate to reject a presidential nominee, but this sort of serial rejection, the idea that a president just shouldn't be able to fill the slot at all, is a relatively new one, with again the kind of odd exception of 1968. Clarence Thomas is a bit of an odd. That's the closest successful confirmation vote in history until recently, but obviously that was more about the accusations against Justice Thomas than a kind of change in the general relationship between the Senate and the President on these things. And you can see that again. Ruth Bader Ginsburg, who was at the time of her nomination actually not considered as liberal as she would be later on, Senate Republicans signaled to President Clinton that they would be fine with her nomination, but again, she was confirmed essentially unanimously. Oddly, Stephen Breyer, who's more moderate, actually got more no votes than Ginsburg did. And again, you can see a little more opposition to Roberts, but he went through comfortably. Justice Alito was a bit of a flashpoint there. there was a pretty serious discussion among Democrats about filibustering Alito, which probably would not have kept him off the court, but would have meant the filibuster for judicial nominations would have been eliminated in 2006, which probably would have allowed Obama to get more nominations confirmed in his first term. But at any rate, that's where you can first see the idea that a qualified judge should be rejected just because they were very reliable votes for the other side sort of really began to take hold. Justice Sotomayor, again, you can see kind of no votes in between Alito and Roberts. So you can kind of see that there's still something to that norm of deference to the president, but it was fading. And again, ironically, Elena Kagan, despite being more moderate than Sotomayor, actually got more no votes. And then you can see, Gorsuch got only a few Democratic votes. Kavanaugh got one Democratic vote, and that Democratic vote was only announced after he got his 50th from Susan Collins. So, that's barely there was, Joe Manchin voted for Kavanaugh because he was running in an election and his vote didn't matter. So, effectively, Kavanaugh was the closest we've come to a straight party line vote. And that was until Coney Barrett, who was confirmed with 0 Democratic votes. So not a single Democrat voted for Coney Barrett, and Susan Collins of Maine also voted against her, but that still leaves us with 51, and she was confirmed a couple weeks before the election. And then Justice Brown Jackson, again, a few more Republican votes than Coney Barrett or Kavanaugh got from the Democrats, but again, many fewer Republican votes than even Sotomayor or Kagan got earlier, and that's despite the fact that again that was not that just replaced one Democrat with another, so it was not didn't affect the balance of power in the court at all. So again, you can see in these trends, a definite change in the Senate's relationship to the presidency on judicial nominations, there's just many ways that that this is visible. So this is basically it, is that when Supreme Court justices are nominated for ideological reasons, they tend to be pretty predictable, especially in the short term. So the reason that Supreme Court justices used to not be political is that presidents, focused on other factors. So it's not as if, William Brennan anybody thought he was a conservative. It's just that Eisenhower's running for re-election. Republicans are making big inroads among Catholic voters. And so Eisenhower essentially asked the Justice Department, find me, I think he asked for a conservative Catholic and got a liberal one, but at any rate, he cared more about appealing to a group. Same thing, Sandra Day O'Connor definitely left something on the table ideologically, but Ronald Reagan had promised to nominate the first woman to the Supreme Court, and O'Connor was the most conservative woman who was a viable candidate for the court. So, it used to be that ideological factors were one concern, but politics was another concern, and there was also that presidents were sort of not as careful about vetting nominees. So it's not as if George H.W. Bush was trying to put a relatively liberal person on the court when he nominated David Souter, but there was this kind of weird internal politics within the administration, and his New Hampshire advisors really liked Souter and he nominated him. Basically, the sort of contemporary Federalist Society is an effort to ensure that will never happen again, that a Republican president will never nominate another Souter, how judges vote as appellate judges, their writings beforehand is all really carefully scrutinized, so judges are more predictable than ever on the issues that matter most to their coalitions. So I think one upshot of this is that it's effectively going to be impossible not only for presidents to get Supreme Court justice confirmed by an opposition Senate, but even circuit court judges. One thing that I'm not sure is widely known is that it's not just that McConnell prevented Obama from filling Scalia's seat. There were essentially no circuit court nominations confirmed once Republicans took over the Senate in 2014, and that's a big deal. There were a huge number of vacancies for President Trump when he took office that transformed several circuits from Democratic leaning to Republican leaning, and that obviously has a big impact overnight. And I think another thing that we should be prepared for in the future is the possibility of some long-term vacancies on the Supreme Court. You might go 4 or 8 years with an 8-member court or a 7-person court. And we'll talk about the scenarios later, but again, things can change. There can be other realignments. I know Professor Maska was in the other day, so we should never assume that this current partisan situation will be permanently enduring. But as long as we have this particular form of elite and ideological polarization, I just don't think an opposition Senate is ever going to allow a president to get a Supreme Court nomination confirmed under those scenarios. All right, so moving from this historical background then to what is at stake in 2024, we have 3 scenarios. And so first of all, Trump wins with the Republican Senate. And I'm just not really going to pay much attention to the possibility that Trump wins with the Democratic Senate, because I just don't, given the math, I just cannot see a situation in which Trump wins but Republicans don't take the Senate. It's not literally impossible, but I think that we can assume that if Trump wins, he'll have a Republican Senate. Then there's the second scenario, which is perhaps the most likely scenario or 50-50 scenario, but if Harris wins, it will most likely be with the Republican Senate. To maintain control, Democrats have to hold Ohio and win one long shot race, whether that's Montana, whether that's Nebraska, Texas. And probably the odds of any of one of those things happening is something like 20%. So it's not impossible that Harris would have a Democratic Senate, but most likely it will be a Republican Senate. And then finally, there is that whatever chance that Democrats win a long shot somewhere and Harris has a Democratic Senate. So we can kind of go through these 3 scenarios in order. So if Trump wins, we're going to be in kind of a traditional situation in which the court is effectively a partner of the governing party. So you think of the Warren Court at the height of the Great Society, or you think of the Supreme Court of the Gilded Age in the early 20th century, when the Supreme Court was a conservative bulwark at a time in which national politics was very conservative. That's a typical arrangement. And one reason the Supreme Court has gotten so much stronger over the years is that generally the Supreme Court tends to serve the interests of the dominant party. That's not exactly what's happening here, but we'll come back to that in a second. But if Trump wins, you're going to be in a situation where, for the most part, Trump and the Supreme Court are on the similar page. Now, it is true that there were some clashes between the Roberts Court and President Trump in the first term, most notably with respect to the Trump administration trying to change the way in which the census was tabulated. One thing is that the fact that this court is 6-3, and also some recent decisions from the Warren Court suggest that there'll probably be less pushback this time. And I'm thinking in particular of Trump versus United States, the case that gave an extraordinarily broad immunity to the president, and the fact that was divided straight party line opinion, except for Justice Barrett disagreeing on a few points. That would seem to suggest that we're not going to get a lot of pushback against the Trump administration from the Supreme Court. And another thing that will almost certainly happen should Trump win with a Republican Senate, which I think is enormously likely, is that, and I just realized I put Scalia. Well, Anthony Scalia will not be retiring strategically, but Sam Alito and Justice Thomas will likely be retiring strategically. So I'll have to change that slide for the posterity. So sorry about that. I was thinking too much historically. But yes, Justice Alito and Justice Thomas are likely to be to retire, like Justice Kennedy did. And the effect of that obviously will not be to change the composition of the court per se, but will mean that Republicans will have a majority on the court, for the foreseeable future, barring some kind of radical change to the Supreme Court. Essentially, you would have a locked-in Republican majority that you could have 12 years of Democratic presidencies, and you probably couldn't break it. The only chance of a composition of the Supreme Court changing would be for Alito or Thomas to leave office under a Democratic administration and Senate. And so that's the real key thing here, is that there are many ways in which the Supreme Court can be a useful collaborator with a sympathetic administration. One thing is that one of the core proposals that President Trump is putting forward is to impose a broad across-the-board tariff on imported goods. During his first term, President Trump issued some more limited tariffs, and he did so based on an act of Congress that authorized the president to impose tariffs that were necessary for national security. Now, you can imagine the Supreme Court, potentially pushing back against that. And I'm thinking in particular on the way in which the Supreme Court pushed back against Biden's executive actions on COVID and on student debt. In Nebraska versus Biden, the student debt case, the basis for that, the $10,000, the student loan forgiveness, was an act of Congress that gave the Secretary of Education the right to waive or modify student loan payments during a time of national crisis. This was initially passed during the Iraq War, but would seem to apply to COVID too. Despite that relatively clear statutory language, the Supreme Court struck down the action, saying that it essentially went beyond what Congress had authorized. It was not intended to provide anything that big. To the dissenters, waive or modify means waive or modify. It's a modification, then it's within the letter of the law. But the point here is that if the Supreme Court were to sort of treat the tariffs like they treated, Biden's student debt waiver, you can very easily imagine the Supreme Court saying, there's no national security justification for these tariffs, they're economic policy, and that's fine. You can agree with that or disagree with that, but the appropriate body to set economic policy is the Congress. My guess is that that will not happen. There really wasn't any movement to strike down Trump's tariffs in court the first time, and I doubt the Supreme Court would push back this time as well. So I think that the Trump administration is likely to have quite a bit more discretion, so that even if Democrats control the House and you have a gridlock Congress, that it's likely that Trump will have a lot more room for executive action. Another thing that's likely to happen is that the Supreme Court will side with the Trump administration when there's clashes between the policies of blue states and national policy. So that's another thing, is that the Supreme Court, will in some cases, I think, take action against the policies of Democratic-controlled states, which will be trying to sort of counteract some of the national policies that would come out if under a Trump administration. Another real possibility here is with respect to abortion regulation, that in theory there could be restrictions imposed on abortion that don't require action from Congress at all. And obviously, if Democrats control the House, there's no way there's going to be a national abortion bill, and probably even a 50 or 51 seat Republican Senate. Even if they were willing to modify the filibuster to pass that, I doubt. Certainly Senators Collins and Murkowski would certainly not vote for that. So I don't think we're going to see any major new legislation. There is theoretically the possibility that the Supreme Court could simply say that fetal life is protected by the 14th Amendment, which would require abortion be banned in all 50 states. I think that's unlikely in the short term. That's kind of a longer term goal. I would never say never, but my guess is that that probably won't happen. I think the more likely possibility is that there's been a movement to sort of use the long disused Comstock Act, the infamous legislation passed in the late 19th century, which on its face would seem to forbid the mailing of materials involved in abortion across state lines. And as the sort of same conservative litigators who got Roe versus Wade overturned are arguing that that applies not only to abortion medications, but to the medical instruments used in abortion and so on. So there's the real possibility the Supreme Court could simply read the Comstock Act to impose, not be a total ban, but to impose severe restrictions on abortion that would apply nationally. So that's in the current state of government. We're kind of in a situation like the late 19th century in which the courts have very wide discretion to act. And abortion is just one example, but you're going to see some creative litigation that in some cases may well succeed. If Harris wins in the Republican Senate, on the other hand, essentially what you're going to have is a situation in which, nothing is going to change. Even if, obviously, Alito and Thomas are not going to resign voluntarily, and if, God forbid, something happened, Harris would probably not be able to replace them. And I do think that this is something that's relatively historically unusual. Despite the fact that we tend to think of the courts as counter-majoritarian, that historically has not really been the case. My friend Mark Graber has said that people talk about the Warren Court as if Barry Goldwater won a huge landslide in 1964. The Warren Court pretty much reflected the politics of the era, as did the conservative courts of the late 19th and early 20th century. What's relatively unusual about this situation is that if Harris wins, it will probably mean that Republicans have a 6-3 majority on the court, despite having lost the popular vote in 8 of the last 9 presidential elections. That is historically unusual. Normally, a strong majority on the Supreme Court is the result of a dominant party. That has not been the case. If anything, Republicans have been very slightly the minority faction over this time, but the way that elections have turned out have put Republicans in the driver's seat. And incidentally, there's been a majority of Republicans on the Supreme Court since 1970. So longer than I've been alive, Republicans have had a majority on the court, and that's likely to endure for quite a bit longer. And again, that's just kind of, when you have a system of life tenure rather than fixed tenure, that's going to mean that there's some luck of the draw involved in these very important positions. And again, I think that President Harris would have much less discretion to go beyond a gridlock Congress than President Trump would. That's not to say that all executive actions would be struck down, but certainly the Supreme Court is likely to look much more skeptically on executive action by a Harris administration than it would of a Trump administration. And again, I think in this scenario, Harris probably would almost certainly not be able to get a Supreme Court nomination confirmed, and would probably struggle to get any appellate nominations confirmed. That last one is a little bit tricky. There is the possibility that, say, Senator Murkowski may prevail among the leadership to allow some appellate justice to be confirmed. She might, especially if it's a 50-50 or a 51-49 Senate, she would have a certain amount of credibility in threatening to caucus with Democrats. So there are some scenarios in which it may not be quite that cut and dry. If Republicans have something like 52 or 53 votes, then I think you can pretty much count on a blockade. But certainly you're going to see some longer term vacancies, and Harris is not going to have the same ability to transform the federal courts that President Trump did and that President Biden has had to a lesser extent. And then finally, if Democrats win the inside straight and have control of the Senate as well as control of the White House, then at least President Harris would generally be able to get appellate justice confirmed. So the circuit courts would start to move to the left. Now, again, it will depend to some degree on who is the 50th vote. If it's John Tester, he's a pretty normal, reliable Democrat. So probably there would be very few nominations struck down. If it's somebody like Dan Osborne, who's an independent, would probably caucus with Democrats, but obviously you can imagine him pushing back perhaps against some judicial nominees. So it would sort of depend on exactly who won, who managed to pull off that long shot. But certainly, Harris would be able to get some judges confirmed, and should a Supreme Court vacancy arise, would probably be able to fill that as well. So that would make a big difference. And do keep in mind that, if Harris wins, there is the possibility that Democrats lose the Senate this year and take it back with a somewhat more favorable map in 2026. It's hard. It's very hard for the incumbent party to gain seats in the Senate during that year, but it's not absolutely possible. So do keep that in mind that, this is relevant if Harris has a Democratic Senate at any point in a hypothetical presidency. But another key thing here is that, whether Democrats have a narrow control of the Senate or Republicans do, certainly Congress is not going to be in a situation in which it can credibly, push back against the court. I wrote a paper a few years ago in a journal called Perspectives on Politics, which argued that judicial supremacy is the wrong way to think about the relationship of judicial power to the other branches. That there's very many cases in which the Supreme Court is not the final say on constitutional adjudication. I still believe that, but it wasn't great timing because the configuration of politics we have now sure looks an awful lot like judicial supremacy. There's not, when the courts adjust the baseline, there's not a lot of opportunity to push back. But it's not as if this is, theoretically impossible. And indeed, one really interesting thing is that in past situations in which you've had a hostile Supreme Court, confronting a majority coalition, this has often been the case of real pushback, because on paper, Congress has a lot of tools it can use to modify the courts or retaliate against them, or however you want to look at it, including the fact that the size of the Supreme Court is not fixed. The size of appellate courts are not fixed, and indeed, under both President Carter and President Reagan, we saw major expansions of the circuit courts. The Supreme Court can limit the jurisdiction of federal courts. There are all kinds of things that, in theory, can be done, and practically they have been done. When the Adams administration pushed through a bunch of judicial appointments after he had lost the election in 1800, and keep in mind then a defeated president and a defeated Congress stayed in power until the first week of March, the Jeffersonians were furious and regarded all those appointments as illegitimate, and so they did a variety of things. The Federalist Congress had called for a Supreme Court seat to be eliminated as soon as the person left. The Jeffersonians first restored that sixth seat and then added a seventh seat after Jefferson was reelected. They refused to deliver appointments that had not been delivered by the Secretary of State, which led to the famous Marbury versus Madison case. And they just completely eliminated all the new circuit court justices that had been nominated. Just said basically these positions are null and void, and they also canceled the Supreme Court term of 1802. Now again, with the possible exception of eliminating those circuit court judgeships, all of these things were clearly legal, as were the actions taken by the Federalist Congress. But they're sort of what's known as constitutional hardball. That is, doing things that are permitted by law, but are problematic from a normative perspective. But the Jeffersonians really kind of struck back and kind of made clear that they were not going to put up with the courts interfering with governance. And the Supreme Court survived in part because John Marshall, the Adams-appointed Chief Justice, was very careful and very strategic, and did not like to challenge ruling elites when he knew he was outnumbered. Andrew Jackson famously, ignored Supreme Court decisions, affirming that the Cherokee Nation had sovereignty over its lands within the state of Georgia, and there's a quote attributed to Jackson that John Marshall has made his ruling, now let him enforce it, with the implication being that the court cannot enforce anything. That's probably an apocryphal quote, but it survives because it pretty much reflects Jackson's position towards the Supreme Court. Another famous example is that Abraham Lincoln, after the Dred Scott decision came down, famously said that the decision was binding on the parties, but was not binding to him as a constitutional ruling. That as a member of Congress, he would still vote to ban slavery in the territories, although the Supreme Court had said that was unconstitutional. Unusually, Lincoln was in a position to do something about it, and he did. He signed legislation banning slavery in the territories, and he also had his Secretary of State give out passports to African Americans, even though Dred Scott had ruled that African Americans, even free African Americans, were not citizens under the constitutional order. So basically, Lincoln completely ignored the Dred Scott decision. Now, so if you want to talk about, presidents pushing back against the Supreme Court, Lincoln is, the example you want to give. There are some less attractive examples, that also describes what southern states did to Brown versus Board of Education in the 50s, essentially nullifying it for 10 years. So again, be very careful about interpreting what you think interbranch relationships should be from individual cases. There's no guarantee. Sometimes the Supreme Court is on the right side, sometimes it's not. But at any rate, it shows that the Supreme Court is not always in a position to impose its will on others. Again, during the New Deal, FDR famously proposed adding 5 new justices to the court. And it's assumed now often that the failure of that plan, despite a huge Democratic majority, was inevitable. But recent scholarship by people like Jeff Schessel and Laura Coleman have shown that it wasn't. Had the Senate Majority Leader not suddenly passed away of a heart attack, most likely the court packing plan would have gone through, even though one Republican justice had resigned and FDR was going to be able to appoint a majority. But again, when the Supreme Court kept striking down New Deal legislation, FDR kept insisting the problem is not the Constitution, the problem is the Supreme Court's misinterpretations. And again, that crisis faded away just because FDR was able to get control of the court after 1937. But so there have been all kinds of examples of the court being pushed back against in history. But the current Supreme Court is just in a much stronger position, and again, it comes back to that partisan polarization. When most of these pushbacks occurred, the presidential party had massive majorities in Congress, essentially, huge supermajorities. That is no longer the case. We're now in a time of close party competition, and we're also in a situation in which one of the two parties is almost certainly going to mostly like what the court is doing. So that means as long as Republicans have at least 41 votes in the Senate, nothing like the kind of constitutional hardball that we saw from the Jeffersonians or was proposed by FDR has any real chance of happening. And of course, the court has also been much more strongly established during this period than it was in 1800. So that's sort of the key thing here, is that in times of tight party coalition, our system does work sort of like judicial supremacy, in that there's just very little ability to push back against the court. I wouldn't say none. There are ways in which the executive branches of the federal government or state governments could theoretically, foot drag and not fully implement Supreme Court decisions, and I think you're going to see more of that happen. But there's certainly not going to be a major expansion of the court or jurisdiction stripping or anything like that. That would require much larger Democratic majorities than are currently the case. And I think one additional problem here is that many of the things that Congress can do with a simple majority, such as expanding the size of the court, are fairly radical reforms that also would have uncertain effects in the long term. A Democratic court expansion would not mean a permanent Democratic majority. It would mean a Democratic majority until the next time there's a Republican trifecta. So that might diminish the power of the court, but it wouldn't really establish a Democratic majority. I think a much more sensible reform would be to have the kind of, fixed term appointments that, are common virtually everywhere else among liberal democracies. But that would probably require a constitutional amendment. And given that right now the judicial situation is very good for Republicans, there's no way you're going to get a constitutional amendment approved by Congress. So the upshot of this is that the Supreme Court is now in the most powerful position it's ever been. And whether that will be true, whether it's a collaborator with the next government or sometimes at loggerheads with the next government. All right. I wanted to leave some time for questions, so thank you.
Okay. So we have about 15 minutes for some Q&A. Maybe I'll start us off. I agree with much of what you say, and you know that I'm a big believer that the court reflects partisan alignments and composition of those alignments.
Yes, Cornell is definitely influenced by thinking here for sure.
But here's what I'm most interested in right now. There is a huge split in the Republican alignment. And in fact, I just read it this morning in the Washington Post. All of the planning that Trump is making for the Justice Department has cut the Federalist Society out. They are now relying on people like Jeff Clark, Trumpsters. And it seems to me that you're likely, if Trump were to be elected in particular president, you're likely to see a split amongst the Republican-appointed justices on the court between the more traditional institutionalists, people like the Chief Justice and like Kavanaugh and maybe Amy Coney Barrett from the Trumpsters, those who are willing to go along with all of Trump's wild policies, people like Thomas and Alito, Gorsuch on some issues. And you might see this on things like, for instance, upholding massive tariffs. I could see that group of moderates siding with Democrats to say that the president can't just impose tariffs at will. And do you see something like that happening?
Yeah, I mean, I think that it's true that is, there's nothing, I think that claims that this is kind of a 3-3-3 quarter are exaggerated. For the most part, the Republicans are on the same page, but there is the potential for some divisions. And there's an irony here in that the appointments of George H. and George W. Bush are actually more consistently Trumpy than some of Trump's appointments. But there is the potential for some division. I can imagine, for example, Justice Gorsuch perhaps being persuadable on the tariff issue, for example. So, he does sometimes side with Democrats Democrats on civil liberties issues. He's a little bit more libertarian, so I can imagine perhaps Justice Coney Barrett has seen some, definitely has broken off from her colleagues. So it's including the case involving the 1-6 rioters. Actually, Justice Barrett fully dissented in that case, so we've seen that. But I do think that one potentially is that 3 years ago I would have put Chief Justice Roberts in with the institutionalists, and you did see him try to stop the Supreme Court from outright overruling Roe versus Wade. But I would say that his decisions over the last year, especially, and not just that the outcome of Trump versus the United States, but how broad the immunity was. I think that suggests that Chief Justice Roberts is perhaps not as institutionalist as we thought. I would also point to, it won't get a lot of attention because it's not in a swing state, but the Supreme Court just allowed the governor of Virginia to purge I think 3,000 voters from the rolls, even though there's pretty clear federal law saying that states cannot do that 90 days before an election. So this is done on what's called the shadow docket, so there was no opinion, they just allowed it to go into effect. But again, that would sort of suggest that there's it was a 6-3 vote, so it does sort of suggest that that Chief Justice Roberts is not quite as institutionalist, at least on some issues, as we might have anticipated. So I think it's uncertain, but you are right that it's not a monolith, and it always does depend on individual issues. There's always the possibility that there may be some splits within the Republican coalition. But I'd also say that's why the sort of passing away of Justice Ginsburg and the nomination of Coney Barrett is such a big deal. There's a huge difference between a 6-3 majority and a 5-4 majority. So that even if there are divisions within the Republican sort of majority, you need 2 rather than 1 to switch. So I do think that makes a big difference. But that's not to say that it can never happen. We have seen it, and you can imagine certain issues on which there may be some factional disputes that get reflected in the court. So I think that's an excellent point. Yes.
Yeah, you mentioned that term limits might be a good reform if it were possible. But other than that, what do you think some of the best reforms could be for the Supreme Court, if any?
Yeah, I think that's the one that I most like, just because I think I think judicial power is most problematic when it doesn't reflect the election results. You might not like what the White Court did or what the Warren Court did, but you can't say that they weren't fairly representative of the people who are winning national elections. I think that that sort of having random life tenured appointments just can cause the Supreme Court to go out of sync with the electorate, and I think that's problematic. But the problem is that precisely because one party will always have an advantage, getting a constitutional amendment is going to be almost impossible. Court packing is a tricky one. And as I mentioned, it's problematic in that it doesn't create a stable equilibrium. It's just going to take, it's just going to, mean, constant cycles of retaliation and counter-retaliation. Really, the only time for that would be if the court is just not allowing one party to govern. It would have to be a situation in which, you're essentially willing to sort of just fundamentally diminish the power of the Supreme Court. There may be circumstances in which that's justified, but I think that at least it has downsides. So that there may be good things that come from restricting the power of the court. But for example, I've seen Democrats say that the way to restore Roe versus Wade is to expand the court. That obviously wouldn't work, simply because again the court would almost certainly be re-expanded as soon as Republicans took over. So I think court packing can diminish the court, but it can't create a position in which the court protects the fundamental rights that you believe are protected. Again, I do think that there can potentially be some value in limiting the jurisdiction of federal courts. But again, I think there'd be some questions about whether the courts would accept that, and again, that would be open to cycles of retaliation. So I think it's a very difficult question, actually. But again, I think that what I would consider to be the best reform, and the one that would bring us into line with most other liberal democracies, would be term limits. But it's very hard to see how that happens, which is part of what makes the situation difficult. But I think it's a good question, and I certainly think it's something that we should be thinking about and considering for sure. Yes.
What would you say to a claim that through the court's immunity decision of presidential powers, the court has rendered itself irrelevant? Suppose Trump is elected and just does as he damn pleases. What could be?
Yeah, I mean, I would say that the court is not irrelevant in the sense that that it may come up in opposition to a Democratic administration or the policies of Democratic states, but certainly it is. In my view, it's a pretty disturbing opinion. That the sheer breadth of that, the fact that a president's official acts can't even be used as evidence in another prosecution. I think that that's just a very broad immunity. And yet, despite the broad immunity, there's still a lot of gaps that have to be filled in, which again will come down to the discretion of the court. So, it's partly the court, sort of taking itself out of potential law making by a president, but it's also really the court taking on a lot of power for itself too. Trump versus the United States is, it's certainly not a clearly established in the Constitution, and it really is a very, very expansive doctrine, given that it doesn't have that clear basis. So, it would almost be, if the court were rendering itself irrelevant, that would almost be preferable to what we're going to get. But I certainly take your point. I mean, I do find, and again, we don't know how it's going to play out, I do find the implications of that kind of broad immunity for executive power problematic. And when Chief Justice Roberts says at the end, this applies to all presidents regardless of party or policy, I don't find that very reassuring. Myself, I think that Democratic presidents who break the law should be prosecuted. I think so. I myself don't take a lot of comfort from that. But to the extent I do take your point that I think that the courts, by basically saying that the federal justice system can't work in the case of presidents, I think that shows a lack of confidence. I don't think that that's warranted. That there would be no other way of stopping frivolous prosecutions except for just providing broad immunity. So, if that's where you're heading towards, I would agree 100%. Yes.
Just not go away from that. Any possibility of taking that broad immunity with a president if we have Harris, or in the final weeks of Biden, to use it, in fact, to attack the court itself, to use it to, in fact, say the primary danger, and I'm going to find an official act that I'm going to put them all in jail, or 6 of them in jail. Is there any way you could make that happen with that immunity?
Well, so
Alex wants that to happen.
What can I say?
I'm fairly confident President Biden will not do that. But one difficulty there is that, again, the contours of what is an official act and what is not are still left up. So almost certainly if judicial power is being threatened, I'm quite confident the court would find, no, that's not an official act, that's a private act. It seems very unlikely that the court would interpret that as to allow it to limit its own power. Again, I think it's a hypothetical. I don't think that President Biden is going to sort of throw a bunch of justices in jail. But again, it is it's pretty disturbing. The idea that nothing the president does as an official act can be seen as being illegal. I don't know if there's any really short-term potential for mischief there, but I think the potential for mischief over the longer term, I think is really real. I hope I'm wrong, but I suspect that it's a decision that we may come to regret pretty severely.
So we have time for one more question. Go ahead.
Yeah. So you have here the Supreme Court's in a stronger position, and I agree with you. But data have shown that the Supreme Court's way more unpopular today than it's been in most of the time period you've been talking about. I'm thinking we're in the situation where we have Harris as president. We're gonna have she's gonna try to do stuff. Supreme Court's gonna block it. You have Chevron out of the way, so it's gonna be open season for lawsuits, and so she'll probably use this as an opportunity to highlight the court as an obstructionist. Do you see any possibility that the court will, in that situation, would kind of modify its behavior because of its lack of popularity?
That's a good question. I mean, I think that the difficulty here is, and I think that's a great point, and it is absolutely true that, the Supreme Court, which was once, by far the most popular of the federal institutions, has definitely lost a lot of that. And indeed, one reason that Trump won in 2016 is that Republicans were still benefiting from this incredibly favorable situation in which the court was becoming increasingly conservative, and yet liberals liked the court a lot more than conservatives did. So it's kind of the Supreme Court was in sort of the perfect position, particularly after Dobbs, that's now over. Obviously, not only has the court become less popular, it's pretty much falling along partisan lines like everything else. That most Democrats have figured out that Earl Warren has been dead for quite some time, and no longer favor the court. The problem is that as long as you're in a situation in which it's hard for Republicans to have fewer than 48 senators and you have a filibuster, there's just not much that can be credibly done about that right now they're in a situation in which there's just not a lot of room to push back. But what I would caution is that what's true in the short term may not be true in the medium term. Again, I think that partisan realignments can happen more quickly than you think. I mean, I don't think if I sat here in 2008 and told you that Ohio, which Obama carried twice, is going to be a deep red state, I suspect that most people would not have believed me. Things can change pretty quickly. If I were on the court, I would sort of think carefully about, sort of exactly how I want to use my power. But there's two ways they can go. They can basically say we want to, pick ourselves, which I think is what Roberts was trying to do in Dobbs. But there could also be we're pretty much untouchable now, and too bad. And I would say that the trend towards the last couple of years of the Roberts Court is kind of suggesting they're more in a YOLO mode than in a we need to carefully husband our authority mode. But as I say, the fact that radical reforms aren't really possible in the short term doesn't necessarily mean that they are in the medium term. And if there are again repeated long-term clashes, history would seem to suggest that at a certain point, if Democrats establish themselves as a real strong majority coalition, that is going to start to be problematic for the courts. Right now they're in a space in which they have a lot of authority. But there's nothing necessarily permanent about that. And I do think that I hope that's something that the justices consider and think about as they deliberate on rulings. But I think that's an excellent point.
Okay, unfortunately our time's up. Let me remind you, we have next Tuesday, Election Day, we have an election prediction panel at noon here, and then we'll have one final event in this series. It's the following week on the 12th. We have Samara Klar from the University of Arizona coming, and she'll be talking about whoever gets elected, however the election turns out, the implications for polarization and American democracy. And she's written a lot on that, so that should be interesting as well. Join me now in thanking Scott Lemieux for a really interesting conversation. Thank you so much. Really good.
Very